Be ready for dictation. 5 seconds to go. Start. The Learned Council has further contended that for classes that are socially and educationally backward, there are constitutionally devised commissions and guardrails to ensure that the benefits are extended only to the deserving sections who are actually socially and educationally backward, but the amendment in question is bereft of any such guardrails or safeguards. The amendment is limited to those classes that are neither identifiable nor have any constitutionally devised mechanism for their identification. The Learned Council would further submit that economic status is transient in nature and would keep on changing, unlike the status of backwardness, which is based on age-old caste practices and operations that are immutable. The newly protected class under the amendment in question lacks historic and continuing lack of adequate representation caused by structural or institutional barriers so as to be eligible for positive discrimination. Further, the reservation is intended to be operative only until there is inadequacy in representation of those classes and not in perpetuity. However, the present amendment prescribes essentially no end to reservation, as there would always be people poorer than others, since the need for reservation has been delinked from inadequacy of representation and the need to show backwardness. There is no natural guardrail or and point to reservations connected with poverty. This constitutes a clear violation of the Equality Code and of the basic structure of the Constitution. In the alternative, the Learned Council has argued that even if this court were to accept poverty and income as valid criteria for the grant of reservation, then 2. The amendment to the extent of other than the class mentioned in clause 4 should be severed from articles 15.6 and 16.6 so as to include the poor of all classes without any exclusion or discrimination. Learned Senior Counsel Mr. Sanjay Parikh has relied extensively on the Constituent Assembly debates to contend that the Assembly was of the clear opinion that the word backward should precede class of people. Therefore, despite being aware of the rampant poverty in the country, the focus of reservations was predominantly on the social stigma attached to the group. Reservation in public employment was given because the framers wanted the backward classes to share state power, and for that matter, they had to be provided equal opportunity. The Assembly intended to extend the benefits of affirmative action to only those socially and educationally backward groups who had been excluded from mainstream national life due to historic injustice, stigma, and discrimination, and thus bringing in any other criteria excluding the communities who have suffered such stigmatization would be a blatant violation of not only the Equality Code but also the very principles of democracy, both of which form part of the basic structure of the Constitution. Learned Senior Counsel Mr. Salman Khurshid has submitted that in India reservation formed a special part of affirmative action. It is within the larger affirmative action circle that reservation finds its place. Drawing analogy with countries like USA, Israel, and Germany, the Learned Council has submitted that indeed affirmative action can be an answer, but it is not the only answer. There are therefore many ways of addressing the issue of economic disadvantage other than reservation, as has been done by these countries. He would further submit that the limit for such reservation cannot exceed 50% except in cases where 20 compelling reasons arise. He has relied on Commission report, Niti Aayog, Multi-Dimensional Poverty Index, along with other reports, and has argued that the question before the Commission was whether there could be reservation for general category people not covered in any other category. The report itself stated that the backward class poor are poorer than the upper class poor. He would underscore the point that poverty is deeply linked to the caste of an individual and the perception surrounding that status. The Learned Council has further submitted that grant of reservation as a measure of affirmative action is a way for reparation and does not lead to economic upliftment. The object of economic upliftment of deprived sections of society can be achieved through other measures of poverty alleviation, but reservation is not the answer, while contending that Articles 15.1 and 16.1 are part of the basic structure of Constitution and that it is only in furtherance of substantive equality that formal equality can be breached. He has submitted that exclusion on the basis of caste straightaway breaches formal equality. Further exclusion of those who are arguably more impacted by this criterion violates substantive equality too, hitting the equality code and resultantly violating the basic structure of the Constitution.